Right out of the gate, the judge sets the tone, and it's not casual. This isn't shopping at Target. This is your life record. Once you make a legal decision here, there's no receipt, no refund, no second chance. So the real question is, how many people truly understand that before they plead guilty?
You know, being in court, it's not like being in Target, Costco, HEB, where if you don't like something, you can when you take a half-ass approach to something, try to do something else. Once you plead, you're stuck.
Well, on today's docket, it looks like she had missed a drug test for bond. We're here for bond violation. Oh yes, Judge, she's here, and she said she was not aware that she had the drug test. I don't know if the manner in which they contact them. I thought they maybe call them for that, but she was originally going to do DWI PTI. She now says she would like to take a time served offer. Would you allow her to do that today?
Why? Why she doesn't want to do the?
Judge, she just said she doesn't
know what's going to test positive for. Is that what it is?
No, Judge, but she just said that the expenses of the program, and she's working right now, and she doesn't have time for the program.
This is one of those moments where the judge is doing more than judging. He's educating. What he's describing are collateral consequences. That means even after you've served your time, your record keeps punishing you. Jobs, housing, insurance, all of it. So here's something to think about. Is a quick way out today worth long-term damage tomorrow?
Come up, Miss Solano.
Well, we had already gotten her approved, and we're kind of on our way to, I think we might even have the contract already even for DWI PTI.
How old are you, ma'am?
25.
Okay. You know, being in court, it's not like being in Target, Costco, HEB, where if you don't like something, you can return it or you get buyer's remorse. When you make decisions in here, they're lifetime decisions that you have to live with forever. And, you know, there are collateral meaning consequences that you may never see pop up as a result of decisions that you make in here. When you plead guilty to an offense, that offense goes on your record and it's there for the rest of your life. And when you plead guilty, you can't take it off. You cannot say, you know what, I have a change of heart. I can't get an apartment. You know what, let me go and try to do something else. Once you plead, you're stuck like Chuck for the rest of your life. I tell you now, I have, you know, every month, people that call me, they go, you know, this lawyer pled me to this case and I can't get an apartment. Can you take it off? I have, like, they pled 10 plus years ago. You know, truck drivers that want to better their life, but they pled guilty to a, you know, a less than a gram case and can never take it off. When you plead to a DWI.
This is a turning point. The judge is basically laying out two paths: short-term convenience versus long-term freedom. A dismissed case versus a permanent conviction. And notice, he's not forcing her. He's giving her agency. But here's the catch. Making the easy choice now could cost thousands of dollars and years of consequences later.
Not only is it very possible that you lose jobs with regard to, you know, making a living with a car, your insurance is going to go up. Your insurance is going to skyrocket. Insurance is expensive as it is now. You pick up a DWI, it's going to be about 4 times what it is now. Not to mention any other consequence that can arise from a DWI conviction. You have the opportunity now where if you are granted entry into this program, if you complete it successfully, they dismiss the case. It looks like you've already have been granted entry into it. The only problem I see now is that you were called upon to take a drug test and you failed to go. I'm going to go send you for a drug test regardless, right?
Yes, sir, that's fine.
Right. But when you take a half-ass approach to something, you get a half-ass result. And it's usually not a good idea to do that with a criminal case. You know, when you try hard, you get a good result. You know, James worked hard to try to get you into this program. Has she been already admitted into it? Do you know?
She's not in PTI, Judge, but she's been.
Right. But I mean,
Yes, Your Honor, the last update was that the contract was signed, the NDA was in.
all you literally need to do are two things. You pay the DA fee and you get an interlock. The DA fee, if you fill out a waiver, they may be able to waive that $300 fee. As far as the interlock, I can't pay for that. I can only pay for it while you're on bond. That's something that you'll be required to pay for. But I tell you now, the $50 to $75 cost you per month now is nothing compared to what you will end up paying with a DWI conviction.
And there it is, the shift. She listens, she rethinks, and suddenly the influence of family and reality kicks in. This is huge. Because legally speaking, choosing a diversion program over a conviction is often the difference between a clean slate and a lifelong record. Question for you. Would you take the harder road now if it meant protecting your future?
So you make the decision on what you want to do. I am going to send you for a drug test right now regardless.
This is fine.
And alcohol test.
Yes,
But think long and hard before you make this decision because there's no turning back from it. Okay? Okay, man. Just hang tight for me.
You want me to approach?
Sure.
Judge, we got Norma Solano's test results and she came back negative. What I was gonna.
Hold on.
Oh, sure, Judge.
Who is it?
Norma Solano. You sent her to go get tested?
Is that Miss Solano?
Yes, Judge. She's right over there.
Come up, Miss Solano.
That's kind of a alternative as opposed to having her plead today. Maybe we can get.
No, I don't want her to.
No, I know you.
She doesn't want to.
She wanted to do time served today, but I was thinking just instead of that, because she's already has the contract, maybe we can give her a couple weeks to talk to some friends and family and see if she would rather
What
go.
do you want to do?
You said you want to do the time served. Or you think you want to do the 1-year program?
Well, I was iffy in the beginning. I just wanted to do the time served, and then I talked to my friends and my family, and they suggested to do the program. But since I got
anytime you can get something dismissed, no matter how, that's always the best result, really, because like I told you, the consequences of a DWI conviction, they're staggering. You never know how it's going to affect you. It will. It's going to affect you. It's just, you never know how and by how much. And with the DWI is big business. You plead guilty, from now on, you're looking at a minimum of 30 days in jail. You're also looking at a mandatory about $6,000 to $7,000 in fines and fees just here from court, not to mention insurance going up, not to mention all the other stuff in your life, how it's going to affect you. Whereas if you do this program, you do well, maybe they'll even boot you out early. If you do everything speedy, you do it quick, maybe they'll take you out early too. Just depends on how well you do. But you have to put effort into it.
yes,
All you do is, there's 2 classes, right?
There's a couple classes and then it's the alcohol monitoring device.
And there's 2 classes, a little community service, and just stay clean. That's all you have to do.
I have clients regularly do everything in 6 months.
Take your time. I don't want you to rush into something now. So we'll set you off a couple weeks. In the interim, do we have the financial affidavit so we can have her doing that as well?
I can send you a copy of the financial affidavit to waive the $300 fee if you qualify, but you need bills and pay stubs and all that to be attached. I can send that to her, Judge.
Please. And I think we may even have a copy here actually for you. So, try to get that $300 fee waived, and then all you have to do is pay for the interlock and just stay clean. What do you think? We'll give you time. I'll give you a couple weeks. If you still want to do the time serve, that's on you. If you want to do the program, great. It's up to you. Take your time.
I think
Yeah, just
Okay.
talk about it.
Take
Yes,
your
sir.
time.
Thank you, Judge.
I'm glad that you're clean and don't miss again. Okay? All right. Good luck, Ms. Solano. Okay? Great. So I guess we'll roll it to Monday then. Yeah, for sure.
Judge, may I approach? Bobby Steyer. He's got a bond violation.
Ready? Come up, Mr. Steyer.
Not sure why he has this device on his phone.
My God.
I don't know, but a bond condition is a bond condition. And when you don't live up to the bond condition, there are consequences, just like anything in life. When you have a criminal case, you have conditions that you have to live by. And when you don't, there are very serious consequences. Mr. Steyer, you're on bond for fleeing a police officer. So the report is that your device is in lockout, and it's been in lockout since 10/24.
Sir.
Judge, can we address the need for this bond condition?
I don't remember the case, so let's do PC real quick,
Yes, Judge.
and then we'll go from there. All right.
So on August 17th, 2024, at approximately 2 a.m., the officers observed a vehicle with a defective tail lamp and tried to initiate a traffic stop. The vehicle had ample opportunities to stop at multiple well-lit parking lots, but drove 0.46 miles of the final stop location. The defendant had red glossy eyes and continuously, I apologize. The defendant had red glossy eyes and the vehicle was running, and the officers also observed a slight odor of an alcoholic beverage from the defendant's body. The defendant had slurred speech and repeated, "I'm just trying to go home, I came from work," but the defendant could not specify his place of work. The defendant denied drinking alcohol, and the officers found an open container of color XO brandy container under the driver's seat and a Taurus pistol under the passenger seat without a holster.
So what bond conditions were on there that they're alleging him to have violated? Let's see. You wanna help me out?
Sorry?
This is Steyer,
Yes.
please.
I have him here. He doesn't have any previous violations, it's just that the device is in lockout.
What device?
The ignition interlock device.
So they put an ignition in a lock. I guess the magistrate put an ignition in a lock on it.
Charged with DWI.
Yes, conditions were ordered on August 28th. And
I get it, but he's alleged of alcohol in the car. I don't know. How, I mean, begs the question, why didn't they charge him?
It should have been a DWCW judge. We're talking to this officer. It should have been a different charge.
I can't say this should have been a different charge. We're supposed to, officers are officers.
Now this is where things get complicated, and honestly, a little controversial. The judge is acknowledging something important. Even if law enforcement makes mistakes, the defendant is still responsible for following bond conditions. So here's the legal tension. Should someone face consequences because of a system error or only for their own actions?
We're supposed to allow them to do their job, and when their job doesn't rise to what folk think it should be, then all of a sudden they didn't do their job right. We want to talk to the supervisor. Officer didn't charge him, he didn't charge him. So he only got charged with fleeing. I don't understand why he's got this device on his
Did they
car.
do field sobriety tests?
They did not, Your Honor.
There was no DWI investigation done at the scene.
Was there any indication that he was intoxicated?
Yes, he had slurred speech, red glossy eyes.
And an odor of alcoholic beverage.
Yes.
Maybe the officer didn't think it rose to the event. At any rate, the officer didn't call it in as a DWI. And whether the state thinks it's shoddy work or not, we don't punish the defendant because the officer did shoddy work.
But we punish them for having bond conditions and not.
I fully understand that, and that's why I wanted to address the need for the bond condition as well as the bond. I understand that the machine's not working or it's in a lockout status, but I'd also like to address why. Why are we having it? So you didn't put it on there.
I didn't, but I think that it's a reasonable restriction when it is, for all intents and purposes, they just didn't charge it because maybe they had an officer that was a rookie, didn't know what they were doing. I can't tell you how many reports that I have see here that might as well have been written in Mandarin, you know?
From the business perspective, this is
I understand
the fact that we have to work with, and if they've got a rookie or if they've got a shoddy investigation, that shouldn't be his fault. Then that's their issue.
But it is his fault for not complying
Absolutely.
with the bond condition. Yes, what happens now, Mr. Steyer?
Just don't say.
What can you possibly say that can help?
I don't, like I was saying, I don't understand why it's locked. I called the people about it. I told them never it's a troubleshoot with your device. We'll try to figure it out on our end. But they never gave me no information about what to do.
He can remedy that today, Judge.
No. I want to figure out now. I'm not going to let him go and then try to figure it after the fact. I'd like to do it now. What do you think? Do you know why it's in lockout?
I don't, that's what I'm looking at right now. So, because for all of our other devices, we have things sent to them, but since we have a the ignition air lock, I don't see anything on the 24th or past that until the email sent to the DVR.
Would you mind looking into, please, as to why it's in lockout? It might take a little bit.
I
And
understand.
have you take a seat in the jury box while we figure this out, and then maybe 5-10 minutes, we'll come back and we'll
I
see.
understand.
And then,
From the defense perspective, we should still address the need of this. I mean, the officer is part of the state. He is part of the state's witnesses. They didn't make the allegation. They didn't file the charge.
And just like that, everything collapses. This is the domino effect in real time. Missed calibration, device lockout, failed test, boom, bond revoked. This is why compliance with even the smallest court orders matters. One slip can cost your freedom. So let me ask you, do you think the punishment here fits the mistake, or is this exactly how accountability should work?
I'm still contesting outside of the fact that the machine doesn't work. And mind you, he didn't make the machine. He doesn't calibrate the machine. If the machine doesn't work, that could be no fault of his own, and we can correct that today. But if
let's do this, Mr. Slider.
Yes.
I was gonna send you now for a drug and alcohol test. Let's see what pops up. No?
That's fair, Judge.
See how he's been behaving while he's on bond.
My drug test comes back with nothing on it. It will let me ask.
This question is if this drug test is free and clear of any alcohol, any drugs.
Let's cross that bridge when we get there.
We'll do, Judge.
Send you for a test now, and we'll go from there. If you're clean, it'll go a long way for you. If you're dirty, we'll cross that bridge when we get there.
Sir.
My only concern, Mr. Steyer, is public safety. Nothing else matters in my life. And if you're gonna play adult games, or if you play stupid games, you win stupid prizes or you get adult consequences, right? When you act like a child, we treat you like a child. If you do great things, then we congratulate you and reward you, right?
Sir.
Okay, just take a seat for me momentarily. We'll be back. All right, Mr. Slider. So, I'm not happy with it.
I know.
It's unacceptable. It's unacceptable. He's in lockout. A court order is a court order. You know, he's in lockout because he failed to go get it calibrated. Not because of this, not because of that, because he didn't call, no. You failed to go get it locked down, or you failed to go get it calibrated. That's why it's in lockout. I send you to go to test, and now you're testing positive for alcohol. Guess what happens now? That's right. Actions have consequences, Mr. Steyer. He goes with you. I'm sorry, but you can't continue to do it, man. It's unacceptable.
Judge, are you revoking his bond? What are you gonna set the new bonds at?
5,001.
5,000 more than the original bond,
Oh,
which is 5,000.
what's it at now? Is it 100?
Let me check.
It's at 100, so 5,001.
So $5,000 bond. Okay.
5,001, yeah, okay.
Okay.
Goes with you. All right. Sorry, Kavita, but it's just too much.
Thank you, Judge.
Delon, you were charged with failure to stop and give information. Yes. Don't say anything. All I'm telling you is what you're charged with. We have to do probable cause. I want to know what happened with the case to see whether we go forward or not. You have the right to remain silent. Anything you say can or will be used against you. Do you understand what's going on? Okay.
Yes, Judge. The officer was dispatched to a crash in Harris County, Texas, and upon arrival, the defendant was blocked in a parking spot by the complainant. The complainant told the officer that she was driving when the defendant attempted to pass her and struck her via stop, but when the complainant approached her, the defendant drove away without providing information. The defendant could not drive far due to traffic and turned into a nearby parking lot. The complainant followed and honked her horn at the defendant, trying to get her to stop. The defendant refused and nearly hit another vehicle while trying to get away from the complainant. The officer observed multiple other places that the defendant could have stopped to exchange information before the location. The complainant approximated damages at $2,000.
Okay. Ms. DeLone, I'm going to find that there's probable cause to go forward with the case. Do you see if she has a valid Texas driver's license, please?
It's eligible, Your Honor.
Do not drive unless you have car insurance, ma'am. I'm making that a condition of your bond. Do you understand?
I do have insurance.
Okay. What do you do for a living then?
I'm not working right now.
Would you like a lawyer then?
Yeah, of course.
Okay. Let me see if I need you to fill out an application for me, and then I'll see whether you qualify. Assuming you do, we'll provide you a lawyer today. Okay, ma'am?
Sorry.
Mr. Glenn, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. The officer was dispatched to a minor crash on metro tracks, and when the officer arrived, they observed the defendant stumbling, making unclear statements, and acting incoherently. The officers believe the defendant may have been intoxicated due to bloodshot, glassy eyes and slurred speech, and the defendant was initially detained for DWI investigation, however, was transported to the hospital due to not being able to stand on his own. During a vehicle inventory, the officers located a firearm on the left side of the driver's seat, unholstered.
Where was it again?
It was on the left side of the driver's seat, unholstered.
So what happened with the DWI? Are they going to file it?
DWI was not filed, Your Honor.
Mr. Glenn, I'm going to find that there's probable cause to go forward with your case. Can you run his license, please?
Yes, Judge.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand?
Your Honor is not eligible.
You will be signing an affidavit with me today promising me you're not going to drive. Mr. Glenn, I don't care what's going on in your life. I don't care if there's a burning building and you have to save 50 kids. If you don't have a license and car insurance, do not drive. Go to DPS, find out what you needed to do, get your license, get it back, and I'll take this off. But until this point, if I find that you drive, it's really not going to go well for you. Do you understand? We are going to give you time to hire a lawyer, so I'm going to have you come up here, swear to us that you're not going to drive. I'll have you meet with Felicia for your bond conditions, and then you'll be headed out there. When you come back, please have a lawyer, sir. Please. All right, come on. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officers were dispatched to a disturbance at a residence in Harris County, Texas. The officers made contact with the defendant and a witness, the defendant's boyfriend. The officers observed the defendant to be highly intoxicated, and the officer tried to ask the witness what happened, and the defendant continuously interrupted and would not allow the witness to speak to the officer. The officer then temporarily detained the defendant, and the witness stated that he and the defendant were eating dinner with the witness's friend, the complainant. The defendant began to get hostile towards the witness and the complainant during dinner, and the complainant decided to leave and go home. The complainant lives 2 streets over from the witness. After the complainant left, the defendant took the witness's keys to his vehicle and stated, "I'm going to find that bitch and teach that old bitch a lesson." The witness then called the complainant to tell her what the defendant said, and the complainant was afraid and then told her neighbor about the threat in case something happened. The defendant then called the witness 5 times in 3 minutes and texted her, "Outside your house, bitch." The complainant was in fear for her life due to the defendant's statements.
So the initial threat is just like an open threat, not made to.
It was actually, it was said to the witness, but then later he texted the complainant directly.
Give me a second. Hello? Okay. Which one is it? Yeah. Just text. Yeah, text me the number. Wait, and then I'll do it. All right, thanks. All right, for now, Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. You know, in life, there are people, when they consume alcohol, they turn into like very jovial, fun, you know, and then there are people who develop horns and a tail when they start drinking. Don't drink. Do you understand? I'm making it a condition of your bond that you're not to consume alcohol or illegal drugs, and if I find that you do, I'm going to put you in jail. Do you understand? No more PR bonds for you. I'm also ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand your bond conditions?
Yes, Your Honor.
How old are you, sir? Do you have an income? What do you do for a living?
I manage the inventory for PetSmart.
Okay. Do you have the ability to hire a lawyer, sir?
It depends. I mean,
What kind of money do you make a month?
it fluctuates. It's not really like, I don't, my checks go up and down depending on how many hours we work.
I need to know exactly how much you make if you want to apply for a court-appointed lawyer. So I can send you home with an application if you'd like. You can fill one out here, but I need to know exactly how much money you want to make. Otherwise, you'll be required to go hire a lawyer. So look, what do you want to try to apply for a lawyer, or do you want to go out and hire a lawyer?
I could apply for one. I don't know.
Okay, I need you to be honest on the application. This is an affidavit that you're filling out. So be honest. I need to know everything about you. How much money you have in the bank, what kind of car you drive, stocks.
I don't have a car. I don't drive.
Just what I'm telling you is I need to know everything about you. How much money you have in the bank, stocks, bonds, mutual funds, IRAs, information of this nature, and then I'll see whether you qualify, okay? Stephen will give you an application. They'll have you sign a reset. You're going to meet with Felicia for your bond conditions, and then we'll take a look at the application. Please.
All right, Judge, next is page 13. Moreland, come on up.
Judge, are we on Moreland now?